my ruling is this. On the law, the defendant has the burden of proving both the fact of the improper comment or question by the clerk of court, Rebecca Hill, to a juror or jurors, and two, prejudice suffered by the defendant, specifically that the Hill improper comments to the juror or jurors influence the juror to vote to convict defendant Murdaugh. The facts. Did clerk of court Hill make comments to any juror which expressed her opinion of what the verdict would be? Ms. Hill denies A, and so the question becomes, was her denial credible? I find that the clerk of court is not completely credible as a witness. Ms. Hill was attracted by the siren call of celebrity. She wanted to write a book about the trial and expressed that as early as November 2022, long before the trial began. She denies that this is so, but I find that she stated to the clerk of court, Rhonda McElveen, and others, her desire for a guilty verdict because it would sell books. She made comments about Murdaugh's demeanor as he testified, and she made some of those comments before he testified to at least one and maybe more jurors. Did clerk of court Hill's comments have any impact on the verdict of the jury? I find that the answer to this question is no. Each member of this jury took their involuntary assignment very seriously. They obeyed the instructions of the court. They obeyed their oath. These good and decent citizens of Colleton County stood to their duty and rendered their verdict without fear or favor. It was a difficult task. 11 of the jurors very unconditionally said they either heard no comment, or if they heard a comment, it had no effect. One juror was ambivalent in her testimony. She was then examined on her previous affidavit, in which she said the effect, if any, that she had was pressure she felt from other jurors. The cases are myriad that pressure from fellow jurors is a part of the normal give and take of jury deliberations. The court is not to inquire in any way about what is said in those deliberations. But the juror, who was somewhat ambivalent, said on her oath at the time of trial twice, and said on her oath before me in these proceedings that she stood to her oath. The clerk of court allowed public attention of the moment to overcome her duty. I have read the entire transcript of this lengthy trial, not an easy task. I have studied in detail all of the authorities cited. I have independently researched the case law, learned treatises, and scholarly articles on the subject. Although there is certainly a split in the federal circuits and in the states on the standard of review, I simply do not believe that the authority of our South Carolina Supreme Court requires a new trial in a very lengthy trial such as this on the strength of some fleeting and foolish comments by a publicity influenced clerk of court. This is a matter within the discretion of the trial judge, and I am the trial judge at this moment. I do not feel that I abuse my discretion when I find the defendant's motion for a new trial on the factual record before me must be denied, and it is so ordered. I will file a fuller order which denies this motion on the grounds I have recited on the record before me as a trial judge and the authorities that have been cited by all parties in this matter. To that end, I will hold the record open. I direct that within 4 business days of receipt by the attorneys in this matter of a transcript of these proceedings, a proposed order by the state denying the defendant's motion for a new trial with citations be sent to me and to opposing counsel. I will allow the defendant 4 business days from receipt of the state's proposed order to lodge objections and or submit an alternative proposed order. Upon receipt by the court of all proposed orders, I will finalize this record, submit a written order, and I will at that time transmit the written order to the Court of Appeals, the court which has remanded this matter to me. This hearing is adjourned.